All right, everybody, we're going to get started in about 2 minutes. I hope everyone is enjoying this rather cold morning here in Southwest Florida. We're not used to this here.
Morning, Sam.
Good morning. Hey, Wade.
How you doing there, pal?
All right. This is going to be an interesting conversation today. We get started in about 1 minute. It's a very important case. Some interesting nuances. All right, everybody, it is 8 o'clock. Let's get rocking and rolling. Today, we are talking about what I would consider to be the most important real estate case in the state of Florida. This is Johnson versus Davis. This is a 1985 case that has reverberated throughout time and continues to haunt realtors to this day. So, because for those of you who've been on my presentations before, I am an attorney. My name is Sam Saad. And because I am an attorney, we start with a disclaimer that says that I am giving you advice. It is advice that you cannot rely on as legal advice unless we have an attorney-client privilege. Nevertheless, I hope it's correct. Just a little bit about me. I am a 20 plus year attorney here in Southwest Florida. I transact properties throughout the state of Florida. I serve on the Legal Resources Committee at the Naples Area Board of Realtors, and I serve on the Florida Realtor Florida Bar Joint Contract Drafting Committee. So that's the FAR Bar contract. We do a lot of things in our office related to real estate, including litigation, probate, estate planning, and association law. I also own a title company, Paradise Coast Title and Escrow. Hablamos Español. We speak Spanish at Paradise Coast Title and Escrow as well. Other people do. I am not as good at Spanish. But we are available for your needs. And we're going to dive right into Johnson versus Davis. Who did what happened? Why does it matter to you? And why do you need to know this case? Um, First off, the parties. So the sellers in this case are Clarence H. Johnson and Dana Johnson. The buyers are Morton Davis and Edna Davis. This case started off in the third district court. That's the Miami-Dade area. And what happened was the buyers sued for rescission of a contract alleging fraud and misrepresentation, and they wanted their $31,000 deposit back. This was a $310,000 house in Miami, in Miami-Dade. And the sellers counterclaimed on the case, saying that they were entitled to the entire deposit as liquidated damages. As you recall from our case, from our contracts, the deposit is the damages that the sellers get in most cases. Not very often do they get additional damages. So it's a very strange case initially. The trial court, that's the court, the first court, gave the $26,000 back to the buyers, gave the $5,000 deposit, which is the first deposit, to the sellers and did not award attorney's fees to either party. As you know from our contracts classes, if you win in a court case, you are entitled under the contract to attorney's fees. This is a very important provision in the contract because it prevents parties from suing and abusing the legal system just to get out of contracts. If you lose, you pay a lot of attorney's fees because you're paying your attorney and the winner's attorney. The Third District Court of Appeal, again, that's Miami-Dade, ordered the return of the entire $31,000 deposit plus costs, finding that the sellers engaged in fraudulent misrepresentation. This went to the Supreme Court of Florida, who affirmed the appellate court under what I consider to be some very interesting and specious reasoning. And we'll talk about that. But let's dig into the facts a little bit. So the Davises agreed to buy the Johnsons' home for $310,000. They paid their $5,000 initial deposit, and then after inquiring about the property and reviewing the property, they paid an additional $26,000 deposit. And the contract did include a roof inspection clause, and the sellers were obligated to make repairs as needed to ensure a watertight roof. It's very interesting. I've got the case here for those of you that want to read it. It's an interesting read. I don't know if it's going to be too blurry, maybe blur. But the Davises noticed buckling plaster. They noticed ceiling stains, and there was a lot of conversation before the $26,000 deposit was made about the windows and the buckling plaster. And Mr. Johnson did tell the Davises the window had minor problem that had long since been corrected, and the stains were wallpaper glue and the result of ceiling beams being moved. So there was a lot of conversation. After paying the second deposit, the home experienced severe leaking during heavy rain when water started entering through the windows, ceiling, light fixtures, and even the stove. So the sellers had hired roofers who estimated that for less than $1,000 they could fix the leaks and could make the roof, in quote, watertight. That was what was testified to by the seller's roofing company. Of course, the buyer's roofing company testified that we need a full new roof for $15,000. And there was some pretty clear evidence in the case that the Johnsons knew of a prior roof problem that they did not disclose, which of course is the crux of Johnson versus Davis. So the issue that the Supreme Court of Florida came up with was whether a home seller who knows of latent material defects that are not readily observable must disclose them, and whether failure to do so constitutes fraudulent misrepresentation, entitling the buyer to rescission and a return of the deposit. That's a quote from the case. So that's the issue. That's the question the court was trying to answer, was whether known latent defects materially affect the value of the case. And of course, as we know now, many years later, the court, why is my slide not changing? The court did determine that where the seller of a home knows of facts materially affecting the value of the property, which are not readily observable and which are not known to the buyer, the seller is under a duty to disclose them to the buyer. So let's break down what this holding in this court case means. The holding of the case is the rule. That's what the court says we have to follow. So where the seller of a home knows of facts materially affecting the value, what does that mean? Materially affecting the value. Well, there are many cases on material value, and essentially you look at the value of the home, you look at the value of the problem, and you determine if it's material. And there is no percentage. So I can't tell you if it's a 7% problem or a 40% problem. It's a facts and circumstances test, which all these cases have pretty detailed fact sections. And basically, what that means is it's going to be a really expensive lawsuit. It's going to take a long time and it's going to be very expensive. But that's okay because if you win, again, you get just attorney's fees paid. So up next, materially affecting the value of the property, which are not readily observable. They're hidden and are not known to the buyer. The buyer does not know about them. Readily observable, I found a great case that talks about readily observable. And if I can find the quote, where did it go? Where did readily observable? A fact is readily observable when it is obvious from a mere cursory glance. That's what the seventh Judicial Circuit Court has said from a 2002 Florida Supreme Court case when it's obvious from a mere cursory glance. So if you look around the home when you're doing your initial walkthrough, your showing of the property, if you don't see the problem, if it's not readily observable, the seller is under a duty to disclose those problems to the buyer. A duty to disclose. The seller must tell the buyer what the problems with the home are that are not readily observable. And the Johnson court said the duty is equally applicable to all forms of real property, new and used. And then the courts going forward have looked at the test for what this means. And basically, non-disclosure looks at four elements in Johnson. The seller must have knowledge of the defect, so it's actual knowledge. If the seller thinks something might be wrong, or the realtor looks at something, says this might be wrong, that's not enough. The seller does have to have actual knowledge, which actually makes this a very hard case to prove because you have to be inside the seller's mind. What did they know and when did they know it? And of course, we talked, the defect must materially affect the value of the property. The defect must not be readily observable, and they have to establish the failure to disclose. So the court went through the facts, and it's a substantial several-page facts section. The Johnson statements denying roof problems were false material, and they were made with knowledge of their falsity. The Davises relied, must have reliance. The Davises relied on the statements when paying the second deposit of $26,000. And then the court looked at the modern trends restricting caveat emptor and promoted fair dealing. And this is what I want to talk about for a quick second. This is what I did not like about this case. First of all, and I'm a Florida attorney, and I'm from Nebraska, and I learned in law school that California is crazy. And this case actually relies on the Lynch versus Savage case from California. And the Johnson court says things like, goes through the cases and talks about not non-disclosure and says, these unappetizing cases are not in tune with the times and do not conform to current notions of justice, equality, and fair dealing. The court goes on to say, modern concepts of justice and fair dealing have given our courts the opportunity and latitude to change legal precepts in order to conform to society's needs. So for those of you that are, more interested in justice and fair dealing than court process, you're going to love this case. But I'm a big fan of process, and I'm a little bit on the conservative side when it comes to judicial philosophy. And so this case is very frustrating to me in that they rely on California law and change what was longstanding buyer beware, caveat emptor case law in Florida. So that frustrates me a little bit. But the roof problem in this case was significant, it was hidden, and it was known to the sellers. And the other thing the court said was that fraud does not require misrepresentation at the time the contract is signed. You can do it later. So if you enter into a contract and then, like in the Johnson case, Johnson v. Davis, you ask the seller, hey, what's wrong with the roof? What's wrong with this wall? Why do I smell something weird? And they don't tell you the facts, the correct, accurate truth, after the contract is signed, you can still sue for misrepresentation. Uh, Drives me a little nuts, but that's okay. So what can you learn from this case as a realtor? And why does this matter so much to you as a realtor? Well, as the heading of this slide says, you must disclose, disclose, disclose. As a realtor, you may represent the seller as the listing agent, but you also have a duty to honesty, fairness, and disclosure when it comes to property conditions. The cases are very clear that you cannot remain silent if you know about hidden defects like mold behind the wall, unpermitted improvements, or a leaking roof. And an as-is clause in a contract will not protect you or your seller. The courts have consistently said that the seller's duty to disclose has nothing to do with the as-is nature of the contract. So don't think that because you have an as-is that somehow you are protected. Finally, think about the failure to disclose can undo your deal. And don't forget, is that you're separately liable as a realtor. So maybe that seller sold that property and moved away and we can't find them and they don't have any money because they paid off a mortgage. Maybe it was a short sale. Maybe it was a distress situation. Maybe they're foreign and they're in another country. But guess who's local and guess who has insurance? You do, the realtor. Your broker's got E&O. You've got insurance. You're nice and easily found on the internet. So you're the one that's going to get chased around and sued as well for failure to disclose. So please protect your brokerage, protect yourself, and disclose known latent defects that materially affect the value of the property. So what are some other cases out there that's similar to this? Actual knowledge is required. Actual knowledge is required. Johnson did not convert the seller of a house into a guarantor of the condition of the house, as Jensen versus Bailey points out. But non-disclosure is fraud. So just because you in the case of Johnson versus Davis, the seller told a lie. But just because you say nothing and don't lie doesn't mean you're not liable under Johnson v. Davis. So think about that. What did I just say, tongue twister with all those knots? You must disclose. It's not enough to stay silent, and definitely don't lie. An as-is clause will not shield you. We talked about that. And even a negligent misrepresentation. You provide the wrong information by accident. That can create liability. Think about that. You give the wrong seller's disclosure, the old one, or something like that. That can be equally bad. So please be very careful in your real estate transactions about disclosing known defects up front. And remind your customers that as is does not mean say nothing. Document your disclosures. Do things in writing. We talk about this in all the time. Document, document, document. Send that email. Put notes in your file. In a lot of these cases, they look at the files of the parties. They look at what they transacted. They look at the emails. They look at the letters back in the day before email, and they take testimony from the contractors. I'll tell you this. The easiest way to bust a seller on Johnson versus Davis, ask them for a list of vendors and then call their vendors and ask their vendors what they know about the property. That's how you get them almost every time. Oh, yeah, the HVAC is great. Oh, good. Who do you use to service it so I can continue the service since it's so great? I use Bob's air conditioning. You call Bob. Bob's like, oh, that place is terrible. He has tons of mold in there. He won't let me fix it. It's too much money. You find that out after the closing. So be very, very careful about that. We have a couple of questions, Susan. If a seller knows and stays silent, how is the truth determined in a court's eyes? Sunshine, like I was saying, you call the contractors and ask them. Look and see. And if it's totally obvious, like in the case of Johnson versus Davis, the water was pouring in. There's no way they didn't know. Um, and then Della, you ask a great question. What if there was a repair years ago or days ago even? Do the repairs need to be disclosed to the seller? So I would say technically no, but absolutely yes. There's no reason. Yeah, we had a leak years ago. We had a repair and it was done professionally. Here's the documentation. I would not hide previous issues. I would say that they were professionally prepared by licensed persons. Permits were pulled and there's no problem now. But are you absolutely required to do that? No. And then, Michael, what's the statute of limitations? Michael, I'm not 100% sure what the statute of limitations is. I believe it is from discovery, though. So that's a good question. What I'll do is I will follow up on the statute of limitations question. I see it a couple of times. Um, and I will put that in my reply email when I send out these slides. One other point I want to make before I open it up to discussion, I assume there's going to be some discussion, is that Johnson versus Davis does not apply in a commercial setting. It applies to new construction. It applies to resale, but it does not apply to commercial. So, Gerald, that answers your question there on the screen. So just be very, very careful in everything that you do in real estate to disclose defects. And this is kind of a short topic, so I will open it up to questions. You can unmute yourself or put them in the chat. Kathleen, what is a PCD? Kathleen, I don't see you. Property can seller's disclosure. No, actually, that's a great question. You are not required in the state of Florida to make disclosures other than known latent defects that materially affect the value of the property. However, I'm sure if you speak to your broker, and I know many, many, many brokers require sellers to fill out a seller's disclosure, uh, I would do that. Especially for those of you, and I see a lot of names I recognize in the Naples area. If you're using the NABOR contract, there are contractual inducements to filling out the seller's disclosure. Like the seller does not have to repair or even negotiate items that they have previously disclosed. So if you use a NABOR regular contract, for example, and you fill out a seller's disclosure and it says that the roof has leaks like it did in Johnson, and then the buyer comes in and says, I want the roof leak fixed, you say, no, I told you about that. You should have put that in your offer. So, um, Bob, no, Bob, that is incorrect. Condos are residential. Commercial would be like an office tower, a building. My office, for example. Condos are residential. So don't get that confused. Um, Cindy, you're saying here, I just sold a condo. I want to check the dishwasher. We found a lot of leaks prior to inspection. Do I need to let the buyer know that what was done? Cindy, like I said earlier, I would absolutely say, listen, we found some leaks in the dishwasher. We fixed them. We checked. We remediated, and there's no problem.
Would you present the bill showing?
I would give the repair invoice. Yes, I would.
Okay.
Chris, you say, how do you feel about seller's shield? I'm not sure what seller's shield is. If you want to talk about that, go ahead. Chris.
Seller's Shield is a company that vends with brokerages, or it could be through your board, and it allows you as a realtor to use the platform for seller's disclosure, but the buyer or seller can basically buy an insurance policy through them. But if you read the fine print, it pretty much covers legal fees, I think up to 10,000 and nothing more.
I've never heard of it, but I'll look that up. Seller's shield. Okay, I'll write that down.
Thank you.
Yeah.
Hey, Sam,
Other questions, Mark?
good morning.
How are
So
you?
is there a presumption of innocence if the agent sued? It's hard to prove a negative. So do they have to prove I knew something and didn't disclose
Yes.
as opposed to
Yes, they
me
have to prove
proving I
it's
didn't know
actual
something?
knowledge. It's actual knowledge. So you must have actual knowledge of the defect. So if you didn't know about it and you can prove you didn't know, then you're good. But that's very hard on both sides. If they talk to the contractor and they come in, the contractor says, "Yeah, I told Bob about that problem years ago," Bob's in trouble. And if Bob told you about it and they can prove that you knew, you're also in trouble. So be very careful. Again, just disclose what you know. It's not the right rule in my opinion, but it is the rule, and it is the rule that we follow in Florida. So that's what we're going to do. Michael, you're saying to protect an agent who is listing agent, would you have the agent read the home inspection? What do you mean by that? I'm not sure what you're asking there.
In this case, if I have, let's say I have the seller, okay, and the buyer does a home inspection and finds something that would be materially deficient. If I know about it, obviously I disclose, but is there a duty to find out because it's readily observable versus it's in a report? In some states, I'm going to say,
I have not seen a case that gives you a duty to investigate beyond observation.
okay, in
However,
some,
remember, if it's readily observable, like if I'm doing my home showing and I see black stuff on the wall, that's readily observable. If I stick my
sure.
head in the air handler and I see green stuff all over the place, that's readily observable.
Sure, but I'm not going into an attic, for instance, because of my size and shape and everything else. So, to that extent, a home inspection for a buyer reveals that there may be something in an attic. Great. Since I represent, or not represent, but I'm working with the listing side, right? If I don't know about it and the seller says, okay, I'm not sure it's mold or not, because there's something black on the wall and I'm not a mold expert. In other states, they don't want me to read the home inspection because then I have knowledge that I have to disclose.
Oh, well, no, I think it would be if you got the home inspection report and just said, I never read that. I don't think a court would look favorably on that. I've not seen that case, but I I, I would not plead ignorance on in this and say, no, I didn't know that. The home inspection report was emailed to me, but I never read it. I think that's another problem. So don't
No, no,
do that.
what I'm saying, in New Jersey, they have the buyer send it directly to the seller. The agent doesn't see it in most cases unless the seller shares it with me.
Yeah, in Florida, I would not go down that rabbit hole and run the risk of being sued and then maybe even finding out that I committed some type of license violation as well.
Yeah,
So
no problem. That's why I said,
I would not use the what I'll call the ostrich defense. Do not stick your head in the sand.
sure.
Yeah.
Okay, fair enough.
So Jessica, you're saying would recurring odor be considered a material defect? No, a recurring odor would be readily observable, Jessica. So if you walk into a home that smells funky, now you're on notice, least to inquire further. So I would say be careful about that as well. Um, Cindy says they're standing on the ceiling from an old roof, and the buyer asks, this is a snowbird condo, and the sister now want to fill out the seller's disclosure. Yeah, if you're selling, we have a lot. This happens a lot in Naples in Southwest Florida, where we have an elderly population. The heirs are selling mom and dad's condo, and they haven't been in it in 15 years, and mom and dad passed away up north. You only have to disclose actual knowledge, what you actually know. So it's only actual knowledge.
Okay, Sam, I'm selling another unit that I know had mold in it, but they totally tore it apart and they renovated it. I have to it smelled like mold. We actually didn't know it had mold, but I saw the black. Do I have to disclose that? Because here they ripped out
I would.
everything.
I
Yeah.
would just say, hey, because you totally renovated. So you're no problem. You say you're by, yeah, there was problems in here before, but it's been gutted and
And the
redone.
guy's dead. The guy
Yeah.
died. Okay.
Yep. All right. Alma's asking, what if the condo had a cockroach infestation? the seller hired exterminating infestation is gone. So that's a great example. You clean up the problem, you fix it, maybe you get it certified by the contractor that it's done. You would not need to disclose that. But again, I would strongly recommend that you do disclose that it's been fixed and it's been fixed properly and show documentation. In Sunshine, I answered your question about I would do a seller's disclosure. It's just the safer way to not get sued. But I'm a not get sued guy. Some people, they'll take the risk. And I've had plenty of clients in 20 plus years of doing this. They say, we're not going to say anything. And I say, well, you're going to get sued. And then they get sued. And then they question, they come back to me and I say, I told you so. So just disclose. Let's see. Cindy answered your question. Sarah's asking, would you want to know that this place had previously been infested? Yes. I would not want to know that, but I feel like I should know that so I can prepare against it. And maybe you don't buy the house, or sell it quickly. Just kidding. Other questions, you can unmute yourself or put them in the chat.
Hey, Sam,
Yes,
I
Cindy.
had an agent that sold us a condo that she knew was infested with roaches. And when my
Yeah.
customer bought it, I didn't know. And she called me yelling at me, why didn't you tell us that this had a roach problem? I said, I never knew. And so I went back to the agent and she acted like she did not know. How does that work?
It's actual knowledge. I think one of the questions earlier that someone asked is Mark asked, how do you prove the negative? I
Yeah.
mean, you have to show actual knowledge. That's it. If you don't have actual knowledge, then the cases have been thrown out. All right, guys, it's 8:30. It's been a half an hour. Oh, wait, I see one more question. Let's see what Ali says. I've been representing a buyer and asked the listing agent for a seller's disclosure. Was told not to require, did not provide one. So the only thing I did was tell the buyer and send an email to the listing agent confirming the conversation. That's all you can do, Ali. If they don't want to provide it, that's it. Tina is asking, what do you do when inspection states there's moisture in a main bathroom? You do further investigation, Tina. You get somebody in there and you look around for the leaks, and things like that. Gerald, you do not have to disclose death in Florida. That's a statute. That's different. Statutorily, you do not have to disclose death or that someone had a communicable disease in Florida. So, and Tina, yes, even on an as-is contract. All right, everybody, thank you so much. I really appreciate you tuning in. Call me with any questions anytime. I'll talk to you all soon.
Thank you.
You're very welcome.